Hey everybody, John Skiba here, and it is I'm wrapping up the end of my day right now, and so something I haven't done in quite a while that I thought I would do is do a live stream and answer questions. I know that I see in the comments there's always a ton of questions and more than I can frankly get to in responding to them. So I thought I would just take a few minutes, see if there's anybody who wants to jump on, put a question there in the comments. I can put the question up on the screen and we can talk about it as far as responding to what you're dealing with. As always, my little caveat to this is that while I am a licensed attorney, I'm only licensed in the state of Arizona. And so I can't respond to, give legal advice. And it's, natural. We've never met. I don't know all the specifics of your case, your situation. And I honestly don't know all the laws in every state. So I throw that out there. What I can generally give is just general information, particularly as to debt collection lawsuits, and some strategies that have often worked in my law practice and I've seen work in other people's practice. So if you do have a question or a topic you want to discuss, you can put it in the comments and I'll try to get to it tonight. We can see if we can help some people out. I wanted to start off by going over a few questions that I get quite a bit in the comments, try to address those. And then I can get to any other questions that may be out there. First, just recently I did a video, excuse me, on the kind of the state of collections in America right now. It's been such a weird year with COVID, but with the situation with collections, I do bankruptcy as well, and a lot of people thought that bankruptcy would be booming in 2020 or even in 2021. And I was looking in Arizona, on average right now, there's about 700 cases being filed a month. And for Arizona, that is just that's super low. Back in the recession back in 2008, there were over 10,000 cases filed a month. And so we're not seeing a lot of people file for bankruptcy, but we are seeing a lot of people who are being sued. I talked about on the video I recently released, that Sherman Financial Group, one of the biggest junk debt buyers, they actually increased the number of lawsuits that they filed in the last 12 months. And so we're starting to see that because they know that people have more money through stimulus checks, through tax refunds, and through some of the other unemployment benefits that have been coming through. So let's see, we've already got some questions here. So if we can get those popped up here real quick. Let's talk about this one. Can I talk about Robo affidavit of claims? Now, Robert, I'm assuming that you're talking about in a junk debt buyer case. Some of these affidavits that get submitted with the junk debt buyers. Some of the defenses when you get sued by a debt buyer is that they didn't loan you money, you didn't agree to pay them money. So they've got to prove not only that you had the underlying account, but they've got to show how it is that they got it. Now, most junk debt buyers, they file in huge volume. The big debt buyers, Encore Capital, who is the parent company of Midland Funding, Midland Credit, Sherman, who has Resurgent Capital, and LVNV, they file hundreds of thousands of lawsuits each year in the country. And so in order to file that many lawsuits on that scale, they do things in huge bulk, including their affidavits. And so what you often will see are affidavits that are just pre-printed forms, and then they literally will have a space put in there for the person who's signing it, the affiant. And they don't have a lot of information. And so when you get an affidavit that's done in support of a debt collection case like that, it's really important to go through there and look, how is it that they know what they're alleging they know? Most of these people, they don't have hardly any information. They usually work for the debt buyer. They don't have any training or information from the original creditor. Everything that they're saying they know is because they're looking at the documents. Well, everybody has that knowledge. If you look at the document itself, they don't know how, Wells Fargo or Chase, how they create and maintain their business records. Those are the things you really need to pick apart. Something that's funny is, as I've looked through these affidavits, I've literally had cases where the person whose name is typed up in the top is different than the person that signed it. You should be so lucky to get a case like that, because not only are you going to get your lawsuit thrown out, you probably have a claim against them to be able to pursue them. So just go through them really with the fine-tooth comb, asking yourself the questions, how do they know what they know? And Is the information in there accurate? Does it line up with everything else that's in the complaint, within the documents they provided? Those types of things. Let's see what else we've got here. All right, I'm just going to throw this one up here. Thanks, Tom, for the comment. Portfolio Recovery Associates, they're one of the country's largest junk debt buyers. Again, they file hundreds of thousands of lawsuits throughout the country a year. The important point here is that a lot of people that are dealing with lawsuits, garnishments, bank levies, whatever it is, to know that a Chapter 7 bankruptcy will stop those lawsuits. As soon as you file Chapter 7 bankruptcy, they put an automatic stay in place, stops the collections against you. That's one way to deal with it. I always say if you get sued by a junk debt buyer, you really have three options. You can fight it, you can settle it, or you can file bankruptcy on it. Those are your three options generally when you're kind of dealing with these kind of things. So that's one of the options that you have there to deal with it. All right, let's look at this one that Matt says, what happens in the courtroom when you file a motion to strike an affidavit? Will the judge ask, and can the plaintiff and the lawyer say during that time? If there's an affidavit, well, two things here, just to make sure I'm understanding that correctly. Affidavits are generally submitted with motions, like a motion for summary judgment, where an affidavit is a written testimony that's sworn under oath and that they use to support typically a motion for summary judgment, where, motion for summary judgment is them saying, hey, judge, we don't need a trial. Just look at our documents and tell us we win. Usually there has to be a motion submitted with that. If the motion is based upon hearsay, if it's something where they don't have the knowledge to be able to testify to it, you can ask the court to strike it in a written motion. But sometimes you'll see with debt buyers, it gets so bad because they don't have witnesses often that'll come to court. So they will try to submit an affidavit in court instead of having witnesses show up to the court hearing. You should object to that. You don't need to file a written motion if they're just trying to submit this to the court saying, hey, judge, take a look at this affidavit. What you can object to it, because that is hearsay. Hearsay is any out-of-court statement that's being offered for the matter of the truth asserted. That's the legal definition of it. And so, if it's easy to recognize hearsay when it's someone speaking, because if someone's on the stand giving testimony, the lawyer couldn't ask them, well, what did the neighbor across the street tell you about this? That's hearsay. You need to bring in the neighbor from across the street to be able to explain what happened. The same thing is also true with a written document. The written document is an out-of-court statement that they're offering for evidence. If they have an affidavit, that shouldn't be allowed. You can object to it as hearsay. They should make that witness be able to come in. And the reason why is not only is it not very, just not trustworthy, that you can't cross-examine an affidavit, that you can't go into the details and really press them on their knowledge. So that's how that would be done. All right, let's see what else we have. Sorry, scanning through. There's a lot of comments already that are coming in. All right. Let's talk about something that a question I get quite a bit as it relates to default judgments. A lot of people contact my law office after judgment's already been entered. Maybe it was entered years ago, and now it's just kind of coming back and causing some grief. They want to know what their options are if you're dealing with a default judgment that's already been entered. The default judgment situation, really, your options become more limited because most of the power is now swung to the creditor because they have that judgment. Once a creditor has a judgment, they can garnish wages, assuming that that's permitted in your state. They can levy money out of your bank. In some states, they can lien your home and cause all kinds of grief there. So if you have a default judgment, what you can do, the first thing you can do is look to see how is it that they got the judgment. A lot of people get these judgments, and this first time they've heard of it is when they see it, several years later. They don't recall ever being served with it, and they didn't have any chance to, present any defenses in court. If you can, my recommendation is to go back to the courthouse and get a copy of the documents that show how it is the creditor got the judgment against you. Usually there's a document called an affidavit of service or a declaration of service where the process server has to tell the court how it is that they came by your home and dropped these things off. And you need to look there and see where it is that they dropped it off. Maybe they went to the wrong address. Maybe they left it with the wrong person. If you have evidence to show that they didn't serve you, in most states, you can file a motion with the court to vacate that judgment, saying essentially, hey, they didn't even do this first step correctly. They didn't give me a chance to defend this. So they want to, you can unravel it that way. But at that point, it's you who has to have the proof to be able to show that they didn't serve you correctly. One way that was kind of fun that we did that in one case that we had some success in getting this unwound is my client came in and said, look, it says they served me here in Arizona on this particular date. I know that didn't happen because I was at my sister's wedding in Wisconsin on that day. And I said, well, do you have any proof that you were there? And she was able to pull up her Facebook page, and she had all these pictures that were timestamped showing her in Wisconsin on that date. And we used her Facebook profile as evidence that she wasn't there, and we were able to get that set aside. If you don't have something like that, and if you can't get it set aside, then really you're looking at either a bankruptcy or a settlement option. Like I said, once they have the judgment, a lot of times it's tough to get those things settled for really low amounts, just because there's not a lot of they already have their judgment. They can really start the garnishments and they can do all that kind of stuff pretty quickly. So that's something where you either need to look at getting rid of it through a bankruptcy or looking at different settlement options at that point. So throw this up here. Frankie, hey, thank you for supporting the channel. I really appreciate everybody who watches the channel and leaves comments, and I really enjoy doing this. It's a good escape from the rest of my job. So throwing them up here, Rick Phillips asking, what do you think about Biden's new credit system thing? How will it affect us? I truthfully don't know all the details of that, as far as that's something I'm still getting into, as far as if they're able to abolish that. With things like that, I generally see that sometimes there's grand proposals that are put out that never come to pass. Something I have seen that's new that is coming down the pike here pretty quick is the Consumer Financial Protection Bureau has worked to change some of the rules as it relates to the Fair Debt Collection Practices Act and how collectors can contact people. You may have seen this in the news that starting in November of this year, debt collectors are going to be permitted to contact you through your social media platforms as long as it's not in a public way. So, for instance, they could direct message you through Twitter or message you through Facebook as a way to try to collect the debt. You can see all kinds of problems that this is going to cause. It's also going to open up, I think, to a lot more FDCPA litigation where people are suing collectors for doing things in a more public way and causing some problems there. So let me see what else we got here. I don't know if I've answered all the questions, but all right. I think I'll answer one more, unless there's anything else that people want to put into the comments. One thing I'm seeing fairly often in my law practice are people who are representing themselves in a debt collection lawsuit, and they have a trial date that gets set in their case, and then they get hit with a motion for summary judgment. Again, a motion for summary judgment is the creditor's way of telling the judge, we don't need this trial date that you set. Just look at our documents and we'll be good. A lot of people, defendants, consumers get lured into a false sense of that we're just going to deal with this at trial once that trial date is set. In most jurisdictions, if a trial gets set and then they file a motion for summary judgment, you still have to respond to it. I can't tell you how many people I've met who have judgments entered against them because they don't respond to the motion for summary judgment because they think, well, there's a trial date set. That's where we're going to be able to deal with this thing. So be careful of things like that. The rules of procedure, you've really got to dig into those. I try to touch on those things, procedural issues, quite a bit here on the YouTube channel, just because the debt buyers and the debt collectors, their lawyers deal with these things all day long. They know that it's just a minefield for people to try to get through, and the little missteps here and there can hurt you. So that's something to really take a look at. A good place, the Cornell Law School. If you Google that, they have this project where they've listed the local rules of civil procedure for each state, as well as Google Scholar is another good one. So let's take a look at this one. It says, I've had my initial pretrial conference with a Midland credit lawyer. No settlement was reached. A collection was submitted to my credit that I disputed via Experian. This one sounds like it may be Arizona specific. A pretrial conference in Arizona, the pretrial conference is set about 30 to 60 days after the answer is filed in the case. It's usually really when the court becomes aware for the first time that there's an actual lawsuit pending. The judge may or may not be involved, but it's an opportunity for the parties to try to discuss settlement and see if there's some kind of middle ground like that. So usually if settlement is not reached at the pretrial conference, at least in Arizona, the case is then set for trial, usually several months down the road. Not clear on the collection that was submitted to your credit, so I'd have to get some more information. There's Cameron says, yes, this is in Arizona. Let's put some of these other questions up. It says, because this lawyer states that I'm unable to negotiate until I send a fax. That doesn't sound correct to me. If there's an active lawsuit filed by Midland Credit, the lawyer is able to talk with you directly. That doesn't sound correct at all. Yeah, I would press them on that. And, you can submit settlement offers all day long, but that doesn't mean just because you've disputed it on your credit. I mean, clearly you're disputing it. You filed an answer to the lawsuit. Otherwise you wouldn't be at a pretrial conference. And so clearly there's a dispute there. I mean, that's the nature of the lawsuit, is that the defendant is disputing it. So, all right. Let's see this question. If you're employed, can you get your court fees waived and you're in Arizona? You can. You need to file, when you file the answer, you need to let the clerk of the court know you would like to have your fees waived, the filing fee. Like in Arizona, if you have a Superior Court case, it's a $245 filing fee. Justice courts in Maricopa County and the Phoenix area, $68 filing fee. You can get those things waived. You do have to fill out an application for it. And if you're employed, you can still qualify for it, but they're going to look on it based upon need. I can tell you typically if you hire an attorney, that application to have the fees waived is not going to be granted because they feel if you can hire an attorney, you can pay the fee. I see there's a typo there. Unemployed. Yeah, if you're unemployed, you can get the court fees waived as well. It's based upon need. Some courts will break the fee up into payments for you, but often, particularly in the justice courts where the fees are smaller, they may just do it all, wipe it all out. Let's take a look at Bessie here. John, you're in Georgia. I got served. I did respond to all the questions, send those to the court, and the lawyer. It's been like 2 months. I've not received anything from them. What can I do next? This is going to be a procedural question specific to Georgia. And so I don't know the rules there. In a lot of states, they are similar to what they are here in Arizona. Most of the rules of civil procedure are similar. So usually there's some kind of disclosure that's got to be provided, usually within a 30 to 40 day period. You might want to check the court's website where you filed the answer, because if you look there, sometimes there's like a self-help packet, excuse me, that you can look at. Will give you some information. I would for sure contact the clerk of the court and see if there's any hearings or any court dates that have been filed or set, or if there's any other documents that have been filed with the court. Sometimes the courts, they try their best, but they'll send something out. It'll go to the wrong address, and you just want to make sure you're not missing anything. Because I've seen it so often where people just kind of let things be, and then they wake up and there's been a judgment entered because they missed something. They missed something in the mail, or something wasn't mailed properly. So contact the clerk of the local court and see if they will, if they'll tell you if anything else has been filed or if there's any other dates that have been set. So, all right. Well, that looks like, that's really the amount of the questions we had today. I hope this is helpful. I think I'm going to try to do this once a week from here on out. I'm going to try to release my videos on a more regular basis. I'm going to try to do something every Tuesday and Thursday. And if this is helpful, let me know. Put this in maybe put a comment on there if you'd like to see more of these live streams in the future, where we can discuss something, some specifics or something that's going on in your life right now. But again, I appreciate y'all watching and supporting the channel. And I hope you have a good night. We'll talk to you later.